All right, welcome back. We've got another crazy one today, and it's going to be a long one, I think. One of our documents is 30 pages long, and it's one of three that we're going to take a look at today. So, as promised, it's Schofield versus Guillard week, at least until we're caught up. And so, for those of you who are new, hi, I'm Joe. I'm an attorney based in Utah. This case is in Idaho, which is that way north. Uh, so, this is the TikTok psychic case where TikTok psychic accused the University of Idaho history chair professor of committing the quadruple homicide at the University of Idaho. And so the professor has sued her for defamation. And madness has ensued. The psychic countersued. That was dismissed because it was frivolous. She tried to countersue the professors. That was quashed because there was no mechanism to bring a counter complaint against the attorneys. And yeah, so basically, yesterday we discussed the subpoena, the attempted subpoena of Professor Scofield's Facebook records by Ashley Guillard and the litigation that ensued about that. And Professor Scofield won that one. It doesn't mean Ashley can't try going after Facebook, although even though she says it would be useless, the court strongly hinted, you should ask. You should tell Professor Scofield, I want this from your Facebook. It's discovery. You must give it to me. But she decided to just go straight to Facebook instead. But so let's scroll down the docket. Like I said, we're behind. So what we are looking at today is docket number 50 and 51. So first motion to dismiss complaint by Ashley Guillard. And then we are looking at the response, docket 51, response to the motion to dismiss, the opposition to the motion to dismiss. And that is going to take a while. Well, the motion to dismiss is what's going to take a while. More specifically, the memorandum in support. So the plan going forward is tomorrow, assuming I finish everything I plan to today, tomorrow we will be going over Professor Scofield's motion for partial summary judgment, which was filed on October 10th. I mentioned in my video yesterday that the response, Ashley Guillard's response, wasn't showing up on the docket yet, and it was due yesterday. So I was recording few hours after it was due. But I mentioned, don't get your hopes up. It doesn't mean it's not in. It just means it isn't docketed. It hasn't shown up on Court Listener because I'm a cheapskate, so I let other people buy it off Pacer for me. So the plan is, like I said, do the motion to dismiss today, try to get through all of that, and then tomorrow deal with the summary judgment. I spent about 30 seconds looking at the response, the opposition to the summary judgment. I'm going in mostly blind, but just from the 30 seconds I spent looking at it, let's just say tomorrow is going to be wild. I mean, I'm positively going to lose my mind. So you don't want to miss that. I promise you. So with that, let's jump into the motion to dismiss. But, well, no, actually, take a sip of my ginger ale. Let's go to the Federal Rules of Civil Procedure first, because, well, you may remember I discussed this yesterday a little bit, but this is important because, let's see, Ashley Guillard has responded. Well, she has submitted 3 separate answers in this lawsuit. One basically doesn't exist. It was stricken because she was in default when she filed it. She had to file a motion to set aside the default in order to even answer. So that answer didn't count. The next answer went over the allowed page limit. So the third answer is the operative answer. So we're going to say May 16th, she answered. Yes. And so yeah, we're saying May 16th she answered. And what we're looking at today, like I mentioned, is a motion to dismiss. Looking at Rule 12B of the Federal Rules of Civil Procedure, there's the 7 options for why you want it dismissed. Motion to dismiss 12B1, motion to dismiss for lack of subject matter jurisdiction. 12B2, motion to dismiss for lack of personal jurisdiction. Our old friend 12B6, motion to dismiss for failure to state a claim upon which relief can be granted. Her motion is titled a 12B1 motion, so lack of subject matter jurisdiction, apparently. I don't know how the court doesn't have subject matter jurisdiction to hear a diversity case on defamation, but we'll see. So the problem she's going to run into here, and I haven't actually read Professor Scofield's opposition to the motion to dismiss, but I have a feeling that one of the things they're going to bring up is this part of 12B, which I mentioned, I think, in yesterday's video. So a motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. So because she answered, an answer is a responsive pleading. I mean, by its very definition, you answer a complaint, you respond to a complaint. It's a responsive pleading. So a motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. The responsive pleading has already happened. So she has waived these 12B motions. But she's going to try anyway. So now let's jump into it. So as I mentioned yesterday, I hate that they split the motion and the memorandum into 2 separate filings, but whatever. And I hate the way that Guillard formats because she doxes herself between the caption and the body of the text, so that's why you don't see the caption when I show you the when we go through this. Whereas Professor Scofield's lawyers, they put their contact information above the caption where it belongs. And, it's not doxing them, it's free advertising. So comes now defendant Ashley Guillard's motion to set aside docket 49. Memorandum decision and order re plaintiff's motion to dismiss defendant's counterclaims and wait. Motion to dismiss complaint. Motion to set aside memorandum decision and order and concurrent motion to dismiss. The carpet does not match the drapes. The caption does not match the docket. So let's take a peek back at so on August 8th, we had the memorandum decision and order. Plaintiff's motion to dismiss defendant's counterclaims is granted in part and denied in part as follows. Defendant's counterclaims against plaintiff are dismissed with prejudice. In this respect, plaintiff's motion to dismiss defendant's counterclaims is granted. An attorney's fee award against defendant is not warranted at this time. In this respect, plaintiff's motion to dismiss defendant's counterclaims is denied. So, in respect to the request for attorney's fees, it's denied. Plaintiff's motion to quash summonses for Wendy Olsen, the attorneys, is granted. Because plaintiff's counsel is not a party to the action, any consent deadline directed at plaintiff's counsel is inapplicable and hereby vacated. Consistent with paragraph 4 of the court scheduling order, plaintiff's discovery plan controls. Okay, so that's where I was looking for that. Saying that which discovery plan controls. I mentioned that the other day. So plaintiff's proposed discovery plan controls unless otherwise ordered. So Guillard wants that set aside. She wants to reopen her counterclaims despite them being utterly frivolous, because she thinks that Professor Scofield saying she's not a murderer is defamation against her, Ashley Guillard, which isn't how that works. But so she wants to set that aside, and she wants, this is just such a bad sentence. So comes now, defendant Ashley Guillard's motion to set aside docket 49, which was the memorandum decision and order regarding plaintiff's motion to dismiss defendant's counterclaims and plaintiff's motion to quash summonses for the attorneys, also referred to as the order, pursuant to Federal Rules of Civil Procedure 60B4 and 60B6. Well, let's take a look at 60. Relief from an order or judgment. So grounds for relief from a final judgment, order, or proceeding. On motion and just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons: the judgment is void, or any other reason that justifies relief. Well, it's definitely not a void judgment. I have a feeling she's going to be creative on any other reason that justifies relief. So the order is void and unenforceable because the court does not have jurisdiction over the subject matter of the action. The court dismissed your claims that you brought in this court. You're saying the court dismissing your claims is void because the court you brought the claims in doesn't have jurisdiction over them. Therefore, you want the court to revive those claims and hear those claims despite not having jurisdiction to hear those claims. It doesn't work that way. I mean, the order is void and unenforceable because the court does not have personal jurisdiction over the defendant, Ashley Guillard. Concurrently, defendant Ashley Guillard files a motion to dismiss the plaintiff's complaint pursuant to Rule 12b-1 with prejudice pursuant to Rule 12b-6. Like I mentioned, she doesn't get 12b-1 and 12b-6 motions anymore. She waived those. But I mean, she files a motion to dismiss the complaint due to Rule 12b-1, but make it with prejudice due to 12b-6. Those are different theories on why the court should dismiss. Remember, 12b-1 is lack of subject matter jurisdiction. 12b-6 is failure to state a claim upon which relief can be granted. Well, if there's diversity jurisdiction, the court has subject, there is a claim that the court can grant relief on, and if there's diversity jurisdiction, the court has subject matter jurisdiction. So both of those theories fail completely. But what she's going to argue is, I live in Texas. The court is in Idaho. Therefore, it lacks jurisdiction. But that's 12b-2, lack of personal jurisdiction. The court can have subject matter jurisdiction and lack personal jurisdiction, but she's arguing the wrong thing here. Yikes. So, in support thereof, submits to the court the attached memorandum in support of the motion to dismiss and the motion to set aside the ruling, order, memorandum decision, and order regarding plaintiff's motion to dismiss defendant's counterclaims, and plaintiff's motion to quash summonses for the attorneys. Signed, Ashley Guillard, August 21st. So that's the motion itself. This is the memorandum in support. It's 30 pages. This is going to be brutal, so buckle up. Introduction. Plaintiff Rebecca Scofield and her attorneys fraudulently filed a frivolous complaint, Scofield versus Guillard, in the improper venue. So is this a 12b-3? Motion to dismiss for improper venue? because 12b1 doesn't suffice for improper venue, because otherwise, why would they have 12b3, motion to dismiss for improper venue? So, so they filed a frivolous complaint in the improper venue, Federal District Court for the District of Idaho, for the purpose of impeding upon due process for Ashley Guillard and for the purpose of harassment in violation of Rule 11. She's really stuck on this Rule 11 BS when, like I said, it's not a cause of action. You can bring a motion for Rule 11 sanctions for filing a frivolous lawsuit, but that's not a way to get it dismissed. It's not a separate cause of action. You've got to follow the rules on Rule 11 anyway, but that's beside the point. Additionally, plaintiff Rebecca Scofield falsely claimed an excess of $75,000 in damages to file frivolous complaint Scofield versus Guillard in the improper jurisdiction. How did she falsely claim an excess of $75,000 in damages? She's claiming over $1 million in damages. $75,000 is the jurisdictional minimum in order for diversity jurisdiction to apply. She's claiming she was damaged a whole lot more than that. And the thing is, it's not frivolous, it's not false. There's an argument about how much she suffered in damages, but this isn't a contract. There isn't a some certain amount. You didn't breach a contract worth $50,000. You do that, and hey, there's a sum certain of $50,000. Unless there's some liquidated damages provision providing, treble damages, you can't legally claim I've been damaged $50,000 and that exceeds $75,000. Whereas if it's not a sum certain, if it's a sum to be determined by the court or by a jury, then there's some cases, I stubbed my toe, therefore I deserve $75,000 in damages. Well, that on its face is pretty ridiculous. But here, it's not. And so we're going to discuss the motion for summary judgment tomorrow, like I mentioned, but this is why it's a partial summary judgment. This is like the Alex Jones defamation trial, the Sandy Hook defamation trial, where there was a default judgment entered against him because he didn't respond. But the court had to have an entire trial on damages because who knew what the damages were? There wasn't there wasn't a contract. There wasn't a some certain amount that Alex Jones owed the victims that he defamed. So they had to have an entire separate trial. In this case, Professor Scofield is saying, hey, judge, rule on summary judgment that I have won. And then the only argument going forward is, how much should I win? And the thing is, even if the ultimate decider of that issue, whether it's the court or a jury, let's say a jury says, you know what, Professor Scofield, we think that you've been damaged in the amount of $50,000. That doesn't, a jurisdiction isn't yeeted and all of a sudden this is thrown out and Ashley Guillard doesn't have to pay anything, even though $50,000 is still less than $75,000. But the damages don't have to be awarded over $75,000. You have to, in good faith, claim a minimum of $75,000 damages to survive a 12B1 motion for lack of subject matter jurisdiction for diversity jurisdiction. So we're going to be here forever. So plaintiff Rebecca Scofield falsely claimed an excess of $75,000 in damages to file frivolous complaint, Scofield versus Guillard, in the improper jurisdiction, Federal District Court, under 28 U.S.C. Section 1332. 28 U.S.C. 1332 is the statute for diversity jurisdiction. If you remember, a few videos ago, I reacted to that sovereign citizens video where there's two jurisdictions under the Constitution by law. And I debunked it because there's a whole bunch under the Constitution. Plus, there's the state constitutions. So diversity jurisdiction is mentioned in the Constitution. It's not called diversity jurisdiction in the Constitution. It's, the federal courts have jurisdiction to hear cases between citizens of different states. 1332 lays out the groundwork, the requirements for citizens of different states to bring suit in federal court. So the court allowed the action despite lacking personal jurisdiction over alleged defendant Ashley Guillard, a Texas resident, and instead attempted to enforce unenforceable orders to include docket 49. The action is in violation of fundamental fairness and procedural due process for alleged defendant Ashley Guillard. You're not an alleged defendant. You are a defendant. What you're alleged at this point to have defamed Professor Scofield. You are the defendant. You are defending yourself in this court. The court has already found that either it has subject or personal jurisdiction over you, this is the appropriate venue, or that you waived it because you didn't properly object. You waived it because you answered and brought counterclaims, thus saying, yeah, court, you do have personal jurisdiction over me. So this is just disingenuous at this point. And the court probably, like, even if she hadn't waived, even if she had properly objected at the right time, the court probably still does have long arm personal jurisdiction because she has probably established sufficient contacts with the state of Idaho to grant personal jurisdiction. The evidence is in the state of Idaho. The witnesses are in the state of Idaho. Well, and some in eastern Washington, but that's practically Idaho. So this is frankly the only venue that makes real sense, because the only person not local is Ashley Guillard. The Fifth Amendment, in application to federal civil cases, provides that nobody may be deprived of life, liberty, or property without due process of law. A void judgment, which includes judgment entered by a court which lacks jurisdiction over the parties or the subject matter, or lacks inherent power to enter the particular judgment, or an order procured by fraud, can be attacked at any time in any court, either directly or collaterally, provided that the party is properly before the court. See Long versus Shorebank Development Corp., 7th Circuit, 1999. So that's just persuasive. It's not binding law. But besides which, like I said, you're attacking the court, dismissing your counterclaims, saying you didn't even have jurisdiction to dismiss the counterclaims that I brought in this court, and I want the court to hear. Therefore, because you don't have jurisdiction, you need to reinstate these counterclaims, which, what? Then Professor Scofield can say, hey, judge, re-yeet because you don't have jurisdiction to hear these? No. Therefore, the law requires that the entire complaint, case number this, be dismissed and all orders deemed void. So you want the entire case dismissed. But that would mean keeping yours dismissed. Unless she just wants the with prejudice part to be removed. It's dismissed without prejudice now to be refiled in Idaho because Professor Scofield has not established sufficient contacts with the state of Texas. Not by any means. Her only contacts with the state of Texas, at least for this, are suing a Texas citizen. So by your logic, if you want to sue her, you've got to do it in Idaho. And guess what? You sue her in Idaho after this is dismissed because of reasons. She just countersues you. You've granted the Idaho court jurisdiction over you because you brought the case. So if you're the plaintiff, you consent to that court's jurisdiction. You grant that court jurisdiction. My furnace is making noises. Probably need to bleed the lines. We've got hot water heat. But you grant the court jurisdiction by bringing the case. So then Professor Scofield just countersues you for defamation, and we're right back where we started. Bingo, bango, blammo, whatever. So background. Beginning on November 24th, 2022, at the request of a TikTok user, Ashley Guillard used her spiritual practice, psychic abilities, metaphysical tools, to include tarot cards, and investigative skills to uncover the motive and details that led to the murder of the 4 University of Idaho students that were killed in Moscow, Idaho on November 13th, 2022. Her spiritual investigation revealed that Rebecca Scofield planned, initiated, ordered, and executed the murder of the 4 University of Idaho students and hired a man to carry out the murders. Ashley Guillard promulgated her findings on TikTok and the FBI tip line. And you'll notice she's being sued for the TikToks, not for the FBI tip line, because it wasn't published on the FBI tip line. On December 8th, 2022, Tracy Horan, practice assistant for Stoll Reeves LLP, emailed Ashley Guillard demand letters from Wendy J. Olsen demanding Ashley Guillard to cease making defamatory statements about Rebecca Scofield and to remove the defamatory TikTok videos. On December 12th, 2022, Ashley Guillard responded to the demand letter by posting another TikTok video that she believed that she did not make any false statements about Rebecca Scofield and did not have to follow their demands. posting a document explaining the substantial truth doctrine as a guide. Despite not having a legal defamation claim against Ashley Guillard, Rebecca Scofield and her attorneys filed frivolous defamation claims against Ashley Guillard in federal district court for the District of Idaho due to the diversity of citizenship and falsified damages of $75,000 or more. Together, they conspired to deprive Ashley Guillard of the freedom of speech, the freedom of spiritual practice, and of the $2 million through the filing of the fraudulent complaint. Now, she's still on this kick that you're violating my First Amendment right to the free exercise of my religion, to the freedom of spiritual practice. And it's like, no, you can do that all you want. You can do all the tarot readings you want. You just can't publish defamatory material. That's the difference. They don't care how you developed your defamatory theories. They just care that you published them. Yeah. The statements they published about Ashley Guillard in the lawsuit were false and defamatory. But they're not. It's in the lawsuit. It can't be defamatory because it's litigation privilege. Heads up, the very little bit of her opposition to the summary judgment I read, she's claiming litigation privilege. That's dumb. That's really, 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 really dumb. The entire complaint is a lie. In nearly every filing, Attorney Olsen lied on Ashley Guillard by making false statements under oath, violating Rule 11, and committing several acts of perjury. Except she didn't. I mean, I'm not going to say that she has not made statements under oath, but let's take a look at the docket. So the motion to quash the subpoena, what we looked at yesterday, the motion to quash, not under oath. The memorandum in support of the motion, not under oath. The declaration of Wendy Olsen, under oath. Exhibit A, not under oath. And what was the declaration? It was just, I am an attorney. As such, I have personal knowledge of the facts and statements contained in this declaration, and I submit this declaration in support of the motion to quash. And attached as Exhibit A to this declaration is a true and correct copy of the notice of intent to serve a subpoena on Meta Platforms, Inc. I declare this under perjury, signed Wendy Olsen. So, where's the perjury? She is an attorney. She has personal knowledge of the facts and statements contained in this declaration. And the only fact that she's swearing to is Exhibit A is what it is. Exhibit A that I'm presenting as Ashley Guillard's notice of intent to serve a subpoena on Meta is the notice of intent to serve a subpoena on Meta. Where's the perjury? So stuff like that is literally the only place that she's under oath. So perjury just isn't available. So In furtherance of the conspiracy to deprive Ashley Guillard of her rights and property, and to embarrass, humiliate, discredit, and harass her, as if 100 TikTok videos calling Professor Scofield a murderer isn't harassment, attorney Wendy J. Olsen and Rebecca Scofield pushed a multinational press release with multiple news media outlets publishing false statements about Ashley Guillard. Attorney Olsen published false statements that Ashley Guillard made false statements that Rebecca Scofield ordered the murder of the 4 students, knowing they are false, for the purpose of using the community's pain and tragic events for followers and profit. Which I put it as, she did it because she's a clout goblin. The statements attorney Olsen published were disseminated on multinational news channels, social media, blog, and news websites. As a result, Ashley Guillard was harassed, targeted, and embarrassed publicly online, social media, through phone and email, nearly every day to current. In furtherance of the conspiracy to deprive Ashley Guillard of her rights and property, and to embarrass, humiliate, discredit, and harass her, the attorneys mocked, denounced, and discriminated against Ashley Guillard's spiritual practice, resulting in the court to join the discrimination of Ashley Guillard's spiritual beliefs and practices by issuing orders deeming it implausible. Ashley Guillard filed 11 counterclaims in her answer to the complaint, which was docket 20, adding the attorneys as defendants to the counter-complaint. The court, under the tutelage of Chief U.S. Magistrate Judge Raymond E. Patrico, it's not under his tutelage. I mean, magistrates can't issue final judgments dismissing. They've got to make the recommendation to the district judge to dismiss, but the court dismissed all 11 counterclaims, falsely claiming that Ashley Guillard's spiritual practice is a philosophy and erroneously claiming that the attorneys are privileged to make defamatory statements about Ashley Guillard in the news media during the course of the litigation. The entire order is completely one-sided, favorably biased towards plaintiff Rebecca Scofield, and an obvious impediment to tribunal impartiality for defendant Ashley Guillard. However, an appeal is not an appropriate action to overcome the obvious lack of impartiality because the order is void due to fraud, lack of subject matter jurisdiction, and lack of personal jurisdiction over defendant Ashley Guillard. This is so bad. So bad. But let's look at her legal authorities and argument. Judgment is a void judgment if court that rendered judgment lacked jurisdiction of the subject matter or of the parties, or acted in a manner inconsistent with due process. Federal Rules of Civil Procedure 60B4, 28 USC, apparently just 28 USC. Constitutional Amendment 5, Clue versus US, from the DC Circuit, well, DSC. And apparently it's from 620F Soup. I don't know why she has umlauts there. But DSC, is that District of South Carolina, I guess? Or I was going to say DC Circuit, but that's either way. Additionally, a void judgment may be attacked at any time by a person whose rights are affected, pursuant to El Cara versus Texas Alcoholic Beverage Commission. Why is she citing Texas state courts. That's the Texas Court of Appeals. That doesn't matter in Idaho at all. Like when it comes to persuasive authority, this is kind of the least persuasive type of court decision. Like, non-court decisions are less persuasive. Like say a law review article, but an out-of-state court. Yeah, she does it again. Because see, also Evans versus C. Woods Inc., also Texas Court of Appeals. Because why? It's she may as well be quoting me. That I'm almost as persuasive. A void judgment, which includes judgment entered by a court which lacks jurisdiction over the parties or the subject matter, or lacks inherent power to enter the particular judgment, or an order procured by fraud, can be attacked at any time in any court, either directly or collaterally, provided that the party is properly before the court. See Long versus Shorebank Development Corp. Is that Illinois? Find some decent, relevant, authoritative authority, mandatory authority. That's what I was looking for. You're just going for the least persuasive of persuasive authority you can find. A party affected by void judicial action need not appeal pursuant to state ex rel lati from who knows which court this is. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights pursuant to ex parte Spalding. Once again, from who knows which court. I'm guessing because this is the Southwest Reporter, it's probably a Texas Supreme Court case. But I don't know because it's not properly cited. Now, I'm curious. She's trying to say the court shouldn't have dismissed her counterclaims for defamation, but the court should dismiss Professor Scofield's claims for defamation because it doesn't have diversity jurisdiction to hear it because Professor Scofield made up. There's no way possible that Professor Scofield can even claim to have suffered over $75,000 in damages. But in that case, how has Ashley Guillard suffered $75,000 in damages? Because her claims would also not be based on a sum certain. Hers would have to have an amount set by a court or a jury if she won. So the court shouldn't have subject matter jurisdiction to hear Professor Scofield, but it should have subject matter jurisdiction to hear her claims because that makes sense. Ugh. So order docket 49 is void because the court, Federal District Court for the District of Idaho, does not have subject matter jurisdiction over the action due to no damages. Once again, the order dismissing your counterclaims You can't get your counterclaims reinstated because the court lacks jurisdiction. In docket 10, the plaintiff falsely claimed damages equitable. No. What? Equitable does not mean equal, amounting to. Equitable damages are not money damages. So her even putting equitable in this sentence doesn't make sense in any way whatsoever, because back in the day, there were courts of law and there were courts of equity. The courts have since been merged. The courts of law could grant money damages, and this is talking civil. You know, there's criminal law, but civil courts of law could grant money damages. Courts of equity could force you to do something. So equitable relief in this case would be for the court to tell Ashley Guillard to shut the fuck up, to stop making public statements about Professor Scofield. That would be the equitable relief. Legal relief is money. So there's no equitable damages here. But she falsely claimed damages equitable to $1.8 million. Equitable does not mean equal, does not mean amounting to. It's so equitable to $1.8 million for jeopardizing Rebecca Scofield's employment and advancement at the University of Idaho, limiting Scofield's ability to perform new studies and produce new work, and severe mental distress for worries that an unknown made-up person may take violent action. They also motioned the court, and once again, motioned isn't a thing. It's moved the court. You move a court through a motion. You don't motion a court. You move to do this through a motion. I know that's petty. That's something my civil procedure professor beat into our heads. He didn't motion it into our head. He moved it into our heads through a baseball bat. They also motioned for the court to compensate Professor Scofield for these harms. She asks the court to award her at least $863,000 for damages to her personal and professional reputation, the equivalent of 10 years of her current compensation at the University of Idaho. She also asks the court to award her at least $1 million for pain and suffering related to her mental distress. Attorney Olsen lied. How did she lie? How did she lie? Asking the court to do something apparently is a lie. I mean, the only factual statement I see in this motion, at least as far as the numbers go, is that $863 or $863,304 is the equivalent of 10 years of her current compensation. That's the only factual statement there. Is that the lie? Everything else in that request is a request. It's a motion. So how is it a lie? But you'll recall when we covered that, she had a basis for that, because she didn't just pull the number out of thin air like Ashley Guillard's accusations. She didn't use tarot cards to arrive at that number. She didn't use a spiritual practice to arrive at that number. She used the precedent set from the Cardi B versus Tasha K lawsuit, which I can't remember the citation because it's not Cardi B or Tasha K in the caption because those are not their legal names. Emily D. Baker covers that case in full, so if you need more information, go watch Emily D. Baker. But it's apparently, so the motion was in bad faith. It's not in bad faith. It's what they want. How is it bad faith to tell the court what you want? Besides which, there's not a whole lot of precedent, but they used precedent. They used the precedent of a social media defamation case. Because Tasha K is a YouTuber, I think. She's a talking head on the internet, on a social media platform, and she was found to have defamed Cardi B. And the court used some formula to say, yeah, this is the amount that you defamed her. And Professor Scofield is saying the Idaho court should adopt the same formula used in the New York court to grant $1.8 million in damages. That's about as good faith as you can get. But Rebecca Scofield had not suffered any damages. At the time of the complaint, Rebecca Scofield's employment and advancement at the University of Idaho was not negatively impacted by defendant Ashley Guillard. The fun fact of the matter is this is a defamation per se case. So she doesn't have to show damages to win. She has to show damages to collect those damages, but she doesn't have to win. She has to plausibly allege damages in order to have diversity jurisdiction. And contemplated damages, the thing about defamation is the damage is somewhat nebulous. Unless it does immediately... Okay, let's slow down. So Professor Scofield is asking for 10 times her current annual salary. Well, she can't sue 10 years from now and say, this is the amount that I missed out on, because if I hadn't been damaged by these false allegations, my salary would have gone from this at that time to this now, based on this is the amount of salary increase that a similarly situated professor not accused of murder has experienced over this time, whereas mine is only down here, so this is my actual damage. But that's past the statute of limitations. So you've got to sue now within the statute of limitations, and while the evidence is still fresh, and project what the damages are. So, Professor Scofield did not lose her job. Defendant Ashley Guillard did not prevent Rebecca Scofield from conducting any studies and did not prevent her from producing new work. Defendant Ashley Guillard did not harm Rebecca Scofield's reputation. In fact, Rebecca Scofield's reputation increased positively as proven by news media, social media, and her GoFundMe fundraising campaign. Speaking of which, I've had her I have had her GoFundMe posted in the comment or in the description of every one of my videos since the GoFundMe, basically. So support her GoFundMe because the lawsuit is still ongoing and it's expensive. So the thing is, we're not looking at her aggregate popularity. If it decreased the positive perception of her in anyone, it's damaged her. If there are people who would participate in her study, but they're like, well, I think you're probably a good person, but I'm not willing to risk it. That's damage. But like I said, this is defamation per se. It doesn't matter if her reputation was actually damaged. It just matters that you defamed her per se as a matter of law. In Hall versus Earthlink Networks, Inc., the Second Circuit considered events that occurred after the complaint was filed where the amount in controversy alleged was made in bad faith. That's Second Circuit, 2005. But what was I'm curious now. I'm curious. Let's see. Okay. So, holding that Earthlink's continued receipt and retention of its system of emails sent to subscribers' closed account did not constitute the advice or the use of a device resulting in an interception under the Wiretap Act. So, this is an easy case just based on that little summary blurb. This is an easy case to differentiate. Because the damage was done in Scofield versus Guillard when the defamation occurred. We just have to figure out a number to apply to that. And the ongoing damage it created counts. But Ashley Guillard's repeated defamations after, that's the equivalent of this. It's extra new conduct by the defendant. You've got to bring a new case for that. And here's the thing. If Professor Scofield wins, which she's going to, so when Professor Scofield wins, when this case is over, when there is no litigation privilege, when Ashley Guillard gets up and says, Professor Scofield's a murderer, she can be taken right back to court. And remember our discussion on collateral estoppel? And that's our friend mutual okay, what was it? So for me and Atosi and Markey and whoever else, it was non-mutual defensive collateral estoppel. Professor Scofield, if Ashley Guillard repeats these allegations after the end of the lawsuit, she will do basically she'll move for summary judgment based on mutual offensive collateral estoppel. So basically what she'll do is she will sue again and say, Ashley Guillard has defamed me by calling me a murderer. I have already won the case, Scofield versus Guillard, this case, which established that I am not a murderer, that I did not commit the murders of that she's alleging. So at least for the purposes of this new case, I want a partial summary judgment. I mean, she'll ask for an entire summary judgment, but she'll ask for a summary judgment on that issue, saying, I want the court to rule based on collateral estoppel, based on this prior lawsuit saying, I've won it. I'm not a murderer. So the only thing that has to be proved is, did Ashley Guillard say it? And I mean, what was she reckless in saying it? But so that's basically what this Earthlink, Hall versus Earthlink would be. So, like I said, it's easily distinguished. But, oh well. Although the GoFundMe was made after the filing of the complaint, it is relevant because Rebecca Scofield and attorneys claimed falsified damages that were made in bad faith. The GoFundMe has absolutely nothing to do with the amount of damages she has suffered. But besides which, by the judging from the citation you just made, Hall versus Earthlink, it's irrelevant because it happened after. I can't. Why? Scofield did not experience any financial or reputational damages. Her GoFundMe campaign, Exhibit A, raised nearly $20,000 with over 300 donations. Jamal Likes It donated $100, commenting, "We are all with you." Cynthia Prescott, claiming to be a friend to be Scofield's colleague, donated $100, commenting, "I stand with my colleague and friend Becca and her family." Sean Collins donated $10, commenting, "From one of your former students, I'm sorry to see you go through this. Good luck." Eric Netege, random guy from Belgium, donated $10, commenting, "I don't have much, but I hope you get the justice you deserve." Amanda Johnston, Idaho alum, donated $25, commenting, "I am so sorry you are experiencing this." Celeste Miller donated $50, commenting, "The professor's case enhances justice for us all." Arthur Patton Hawk donated $175, commenting, "Becca, you're a hero in so many ways." As exemplified by her GoFundMe fundraiser, Scofield's personal and professional reputation has not been damaged, nor was she at threat to lose her job. But it's defamation pro se. Cardi B is still a mega famous musician. I'm sure she didn't see any dip in her concert revenue, in her streams, in her album sales. Not that album sales are a thing anymore, but she, in fact, saying Cardi B is a hoe and she satisfied herself with a Coke bottle. I think that's the gist of what Tasha K alleged. I don't care. So, for a rapper, that might have actually enhanced her career prospects. I'm not saying it did, but it could have. Her income could have increased because of that. But it's still defamation per se. And the court has to figure out what the damages are. So, Scoffield falsely claimed that Ashley Guillard caused her severe mental distress and that she cannot sleep, cries often,